the company directors are the people who run the show, but because they're the people who run the show, they're also the people who can get stuff done in an inadequate fashion and lose the company money. So that clearly leaves a lot of people pissed off because they're losing money. So when we talked about directors' duties and the way in which directors' duties are expressed, we came across a whole range of things that inform our understanding of how a company could be properly run and make money for its shareholders. That is the primary objective, right? Make money for the shareholders. So the director's duties came out broad categories, one of which was, what are the rights that they've got, the obligations, how do they carry them out, but also quite a lot of information about conflicts of interest. And what happens if you're a decision maker, but you're pulled in two different directions, and how do you make decisions, how to address those? What was the primary way in which we were dealing with conflicts of interest? Disclosure. Either an individual director is involved somehow in something that is the company's business, and then they need to disclose that problem to the rest of the directors and ask for permission to carry on, or maybe the board as a whole is affected, so then they need to disclose this to the shareholders. There are actually some cases where an individual director could be the one affected, but what's going on is so serious that needs approval by the totality of the company, including the shareholders. And that's how you get away with this problem of having difficulty making up your mind when you're trying to serve both a personal interest and something that is supposed to be the interest of the company. Now, all of these things go wrong in a variety of ways, but we're left with the issue, and this is where we're coming into today. If something has gone wrong, and we know that the company can then pursue the directors for having lost money and to correct the mistakes that they made and all the rest of it. But it just leaves us with this problem that if the directors are the people who are running the show, because the company is not in a position to make decisions by itself, it is a virtual entity. If the bosses are the ones doing things wrong, who is going to take the initiative to defend the company's interests? The company can only speak through the board of directors, but it is the board of directors that messing things up. They're unlikely to have an epiphany and blame themselves. So if the totality of the board is involved in some sort of misbehavior, they're clearly not going to call themselves out. If one of the directors is involved in some misbehavior and he's in the minority in the board, it is possible that there are enough independent directors that will take some action. Do you remember what we were saying about non-executive directors? So who is a non-executive director? What are they supposed to do? The non-executive directors are precisely people who are not involved in the kind of day-to-day stuff, but they have a degree of independence from the people who actually operationalize everything that needs to happen for the company. So if you have a bigger structure where you have a group of people with executive functions and people that are non-executive, you would hope that if one of the directors or perhaps a few of them do something wrong in their executive function, the people who are non-executives who see this, they're going to go, hey, hang on a second, what is this? And then they're going to motivate the company to pursue the directors to correct whatever has gone wrong. But if it's a smaller structure and they're all in on it, or the director who's misbehaving is then supported by the others because they're friends or they're very closely linked, or it's one of these situations where they cover each other's backs when they do something wrong, then we have a situation. So it's great to say that the company is an independent entity with independent decision-making capabilities and all the rest of it, and this is carried out by the board of directors. But if the board itself is malfunctioning, there's nobody left to act on behalf of the company. Perhaps AI will be a solution. Do you guys have problems with the concept that AI might be given personality and might be recognized as like a person with its own initiative and rights and obligations and all of that stuff? It's not like we don't have examples of this happening in the law, because corporations are the example. Because you're having all these debates in the press, that AI is going to reach a point of independence in its behavior that we might have to recognize it as a person. And everybody's like, oh, that's crazy, that stuff cannot happen. But we do recognize corporations. That's the whole point of these classes, right? We do recognize corporations who are virtual entities as having separate legal personality and having rights and obligations. I mean, to an extent, we recognize rights on animals as well. We certainly do. even though, so they have like independent behavior, but they don't have decision-making capability, right? But we still recognize rights and we try to protect those rights. If you look at it from that perspective and you're not thinking about the ethical implications, but you're thinking about the practicalities of using the law to recognize personality in artificial constructs, I think there's a good parallel between corporate law, like companies are artificial constructs, and AI as a sort of artificial entity that might attain legal personality. Maybe in a few years' time, when this class re-emerges from the ashes like a phoenix and establishes itself as an independent module yet again, we'll be able to talk about companies represented by AI that actually run themselves. It's going to be awesome. So that way we don't have to do anything. We can sit at home and starve to death. Right. Okay, that aside, I think everybody appreciates the problem. If the artificial entity that's the corporation can only act through the agency of its directors, if the problem's coming from the directors, we need somebody else to take charge. So who is this somebody else? So we're starting this discussion by trying to see what mechanisms exist in the law that will allow other people who are not the directors to step in and defend the company's interests. By the way, if we need a quick reminder for context of what were the duties of the directors, right? The key obligation of the directors is to act within their powers, which is in 171 of the Companies Act 2006. Then they're obligated to promote the success of the company. What this means in practice is make money for the shareholders. They are supposed to exercise independent judgment, meaning that they cannot subcontract their decision-making to somebody else who is external and then say, well, it wasn't me, it was somebody else. They're obligated to exercise a reasonable care, skill, and diligence when they're making decisions. Incompetence will eventually lead to trouble because it will be perceived as a breach of directors' duties. They've got what we already talked about, the duty to avoid conflicts of interest. So when they're acting in company business, they're supposed to be 100% focused on the success of the company. If there's other objectives, especially of a personal nature, that they're trying to achieve, then we have a problem, and this will be perceived a conflict. They're not allowed to accept benefits from third parties, and they're under a duty to declare interests in anything that is forward-coming if, again, it raises a conflict of interest. So the directors are supposed to do all these things. How do we know that this can be achieved when the board itself is the source of the problem, but the board is not calling itself into account to defend company interests? This came up in the courts very early on. Because as you can imagine, ever since the idea of a modern corporation was established in the Victorian era, at like the beginnings of the 19th century, we started to come up these problems that stem from agency relationships. In every agency relationship, as you may have come across in commercial law or related subjects, aligning the interests of the agent and the principal is always a problem. How do you ensure that somebody is working for the benefit of whomever hired them and is not working for themselves? This came up in the courts in the most notable way in the case of Foss and Harbottle. This is an old case, like from 1843 already. And the scenario there is typical. You've got the bosses behaving in a way that harms company interests. And the key point here is that their behavior is not disadvantaging a specific shareholder, but their behavior is detrimental to the company's business as a whole. And making this distinction early on is important, and this will have consequences going down the line. So the court in Foss and Harbottle sits down and tries to think about this. How can we defend corporate interests when the complaining party is not the board of directors? What right do we allow external people, like a shareholder who has noticed that something goes wrong? What right do we allow them to come to the court and complain on behalf of the corporation? Again, this is something that's important. They're not complaining for themselves. They're complaining on behalf of the corporation. The court says there are a few fundamental rules here. One of them is that the directors are the bosses. So the management of the corporation takes place by the directors. And the second one is that kind of flows from this, is that the proper plaintiff, so the proper person to complain for something having gone wrong with the company, is the company itself. Therefore, accepting the complaints of a third party, for instance, one of the shareholders, can only be accepted as an exception to these rules. Again, fundamental rules. The bosses are the directors, they're the ones running the company. And secondly, the right person to sue on behalf of the company is the company itself. So anything else, anybody else who takes the initiative needs to be as an exception to these fundamental principles. What does this mean in practice? It means that shareholders should not assume they have the right to go and complain if they think something's going wrong. They have no independent standing to go to the court. Now, you guys are probably familiar with concepts like the doctrine of privity and all the rest. Does anybody remember what that is? So for instance, when you were doing contract law, what is the doctrine of privity? She hires you to edit her Instagram posts, and you do a terrible job. And I've seen those Instagram posts. I'm thinking, this is a disgrace. It's like an affront to culture and social media. And I would like to sue you for having done such a terrible job on your contract with your colleague there. Can I do that? No, I don't have standing. That's the doctrine of privity, right? Privity means that you have rights and obligations arising from contracts if you're a party to that contract. How do we figure out if you're a party to that contract? You have provided consideration. I, may legitimately be offended by the terrible job that you've done, but I really cannot sue you on your contract. It needs to be your contracting party. Similarly, for a corporation, the person that's in that deal is the corporation itself. So we need an exception that allows a third party to get involved. To take back the example from contract law, the exception to the doctrine of privity is that you've got a third party that's supposed to benefit from the contract, and the contract has given them that capability of being involved in enforcing the contract. So if she hired you to edit my Instagram posts, so I'm the beneficiary third party, and my rights to respond are not excluded in your contract, then I would have the right to sue you. But that would be an exception to the normal rule. Now, the exception that the court came up in the case of Foss and Harbottle is called fraud on the minority. If the directors are not simply doing a bad job, but they are actually trying to harm the shareholders to the level that the court, you should read the case because it's interesting, but the gist of it is, if what is happening is effectively trying to defraud the shareholders for the private benefit of the directors, then that creates an exception to this rule because it demonstrates that the company is now dysfunctional, that the board cannot be trusted to take independent action to protect the company's interests. So as an exception, the court will give the right to a third party, in this context would be the shareholder, to sue on behalf of the corporation. So the court would recognize a shareholder as the initiator of an action on behalf of the company. So nowhere at this discussion are we saying that the victim is the shareholder. The victim of whatever has gone wrong is the company. But we just need somebody to initiate the action to defend those company interests. So once the court accepts that fraud on the minority has taken place and accepts standing for the shareholder, then the action is not personal to the shareholder, but becomes an action of the corporation. So the court basically passes on this action to the corporation, and then the corporation is the beneficiary if they win, but is also responsible for costs and all the rest of it. So the shareholder is not going to have to pay for the trial by themselves. The corporation takes care of all of this stuff because from that point onwards that the court has taken it on, it becomes a corporate action. Does this sound like a good solution to this problem? Why not? Actually, it's the only solution to this problem because you cannot, in this context, I'm referring to shareholders as a third party in relation to the action. But in fact, the only people inside this problem are the directors and the shareholders. Because technically, the directors and the shareholders are the people who are inside the corporation. Everybody else who might be affected, we were discussing, is called a stakeholder, who has sort of legitimate business with the company and is affected by its behavior, but does not affect decision-making. The only people who affect decision-making, fortunately or unfortunately, are the directors and the shareholders. So if you don't recognize the shareholders as having standing to bring an action when something goes wrong, you got nobody. I mean, it would be a lot more difficult to recognize a truly external party, like an external investor, a bank that gives a loan or somebody, as having the capability to defend the company's own interests. So from a theoretical point of view, there's nothing wrong with this. It makes perfect sense. Technically, though, it's a bit tricky. Because to say the rule is proper plaintiff, the rule is management by the directors and all the rest of it sounds grand, and to call everything else an exception also sounds grand, but if you don't have exact criteria how to benefit from this exception to bring an action, then you run into trouble. And they did run into trouble. So if you look at case law that comes after this, so you see cases like Edwards and Halliwell from 1950. You see we got some cases before Foss and Harbottle. But if you want to look at more modern interpretations of these rules in Wallerstein and Moyer from 1975, we do have a continuing problem in trying to figure out what needs to happen for something to come within this exception of fraud on the minority. What is usually the conclusion of the common law being inconsistent? So if we can't figure out what's going on through the cases, what usually happens? The government legislates. So if there's a problem and the courts are struggling to arrive at a kind of workable solution, then that usually prompts legislative intervention. That's why we have a parliament. Okay? The parliament is not just to elect our mates as MPs, give them a salary and expenses, and have them going on trips. They're supposed to be there to respond to needs to amend and improve legislation. So what happened there, because the criteria for using this exception, which comes under the broad heading of derivative action, because the courts couldn't get to a point that we had consistent application of those rules or even a secure understanding of what the criteria are, then there was legislation to put this into a legislative setting. Now, as you probably know, but I think it's worth mentioning again, we are looking at case law before and after a legislative intervention. Because obviously, case law after is relevant because it shows us how the courts are interpreting the new rules. But since the problem is common and is consistent historically, looking at case law before what happened is helping us understand, or is helping us create arguments that we could use in court. So there's solid reasons to look at case law before and after a specific act of parliament, and it informs your understanding. Now, in practical terms, if you were addressing an essay question that says, derivative actions have been a mess, and assess the extent to which the Companies Act 2006 has improved the situation, then you have to look at the law the way it was before and then the way it evolved. Otherwise, you wouldn't be able to have a meaningful discussion. If you're answering a problem question, there is less emphasis in the law as it used to be historically, because in a problem question, you're trying to find a solution to a current problem right now. So what you're interested in is the law as is applied right now. So in a problem question, you would be looking at prior case law to help you understand what's going on, to give you arguments that you could present to the court and all of that stuff, right? But it's not obligatory when you're answering a problem question to go through a sort of historical evaluation of what the law was about. So if you were answering an essay question in the area of derivative actions, you inevitably need to discuss Foss and Harbottle and the reasons why the case law that stems from this is not terrifically satisfactory. But if you were answering a problem question, I would start from the statutory impression of those rules and then apply it to the facts as you've got them now to try and give a real life solution to the problem that you're presented with. And if the case is like super complicated and you need to draw arguments to convince the court about something that's not that obvious, then I would look kind of case law that has developed before and after the act. Where is this in the Companies Act? So this is beautifully located in the Companies Act in section 260. That gives us this statutory impression of what are derivative duties and how we're supposed to do them. So it says here that a member of the company can initiate an action. Now, this needs to be something that the company itself would be able to complain about. No, we're not complaining about random stuff. We're complaining about something that would be a violation. That if the board of directors was independent enough or competent enough, they would be pursuing for themselves. So we have a valid, live cause of action, and the purpose of this is to seek relief on behalf of the company. So the shareholder is not complaining that their personal position is being disadvantaged. They're complaining that the position of all the shareholders in their totality is being disadvantaged. You can only do this about something that the directors are actually doing, so you cannot use this complaint in a prospective sense, being like, oh, I don't like the directors, maybe I can get rid of them by initiating this. This isn't it. It needs to link to something specific. And it's subjected to a specific test as to whether this is in the company's interests. No, this isn't a free pass to the court every time you have a pissed off shareholder. You need to identify a real problem that has a consequence for the company. If you remember back to previous presentations about directors' duties and the effects of their violation, it's quite possible that the directors are breaching their duties, but this does not cause financial harm to the company. Can anybody think of an example? It could be that the Articles of Association say that the directors are not allowed to make investments without the consent of the board or the consent of the shareholders if the amount exceeds £100,000. A director goes and invests £200,000, and then they make £1 million profit because it was a great investment. So this is a violation because they breached they did not stay within their powers. You remember this was one of the fundamental rights, 171, act within the powers. They have acted in violation of their powers, but this didn't actually cause financial damage to the company. So what would be the point of suing? Because they actually made money. So you don't have a live cause of action that can promote the company's interests, even though nobody doubts that there's been a violation. So if you're in that situation and the shareholders are really pissed that the directors are not respecting their boundaries and they're doing whatever they want, what should be the appropriate thing to do for the shareholders? So as a group, the shareholders are thinking these guys do whatever they want, whenever they want it, and when we complain, they go, well, we made money anyway, what are you complaining about? So what could the shareholders do? They can get rid of them, because the problem with saying holding them accountable is you could hold them accountable and then ask them to repair whatever damage they've done, but if they've actually made money for the company, there's no damage to compensate. Yeah. So one way, if the shareholders decide that they don't approve of this behavior, one of the things that they can do is to dismiss the directors. If the shareholders are unhappy with the board and they want new directors, they can dismiss the existing directors. The mechanism is in section 168 of the Companies Act of 2006, and it requires an ordinary majority. So if more than half the shareholders are unhappy with the directors, they can get rid of them and then they can appoint somebody new. But what they shouldn't do, and actually they're not allowed to do, is to bring a derivative action, so track the company to court to complain about something that has not caused any damage. So the criteria in 260 is you're complaining about something done to the company, but by pursuing this action, you're also trying to get something that is beneficial for the company. This isn't simply a mechanism to express dissatisfaction. So if somebody is trying to correct something that the directors have done and achieve compensation for the corporation because the company has suffered loss out of the wrong thing that the directors have done, then the way to do this is to use Section 260 to petition the court for a derivative action. The court will accept this to proceed if there's in fact money to be made, and I'm guessing if the amount is minor and it doesn't even cover the cost of the trial, that an action would be damaging for the company. It doesn't create great press. So you need to be able to get back something that is substantial. Right? In that case, the court will approve it. The court will say no if you don't have a significant interest, so there's no significant compensation coming, and the court will also say no if the initiator of the action is trying to protect something that's very personal to them, that bothers them, but does not affect the rest of the shareholders. There's another mechanism that we're going to talk about in the next presentation about dealing with something that affects you personally as an individual. But this isn't it. The derivative action is to defend the interests of the company as a whole, the totality of the shareholders. How do you actually practically approach this if it comes up in a real-life scenario? You will need to identify what has gone wrong. So to be able to address these issues about correcting wrongs that have been done to the company, and this comes under a bigger label that's called minority shareholder protection, perhaps for the reason that it's usually the majority either in the board or the other shareholders that are sort of ganging up and carrying out something inappropriate. So you might see these discussions under a heading that says minority shareholder protection. The initial point that the trouble is coming from is going to be some breach of directors' duties. Because again, remember, it's not appropriate to go and complain that the directors are not doing the jobs every time the company loses money. Sometimes companies make money, sometimes they lose money. It doesn't suggest that somebody has done something wrong. Business decisions have got beneficial or can have detrimental consequences. Sometimes the environment changes and it's outside anybody's control. Sometimes the best thing to do right now turns out to be the wrong thing, but you couldn't have guessed when you were making that decision. Yeah? So I don't want to create the impression that any of those tools are mechanisms to complain when the company has lost money. They're a mechanism to complain when the company has lost money arising by some sort of violation. Therefore, to be able to address these topics, you need to have a background understanding of directors' duties, because this is where the violation is going to come from. So the starting point should always be, do we have a violation here, or are we simply complaining about having lost money? Losing money in itself is not an actionable thing. Losing money because somebody has done something wrong that they were prohibited from doing, that's an actionable thing. So you find the violation. You have to be sure that the violation has resulted in significant negative consequences for the corporation, because again, a violation that doesn't lose you money is nothing to complain about. So you got the violation, you got the loss, and you arrive at the decision. Can the company be convinced to pursue this? Can the shareholders at the general meeting have a declaration or something that requests the board to pursue a director who's been in breach? If that doesn't work, because they do this and the board of directors refuses and they don't have a valid reason for that refusal, are we then talking about the shareholders bringing this to the court on behalf of the corporation through the tool of a derivative action? And if that's happening in a real-life situation, then you have to advise them on the basis of the current law. So you would be starting from Section 260 of the Companies Act and then going from there to look at the facts and structure your argument. If it has not, if this is an essay-style question that is asking you to reflect on the evolution of the law, then you can start from Foss and Harbottle and just take us through the whole thing of what necessitated this change in the common law and then how it moved in its statutory impression and all the rest of it. The conclusion is going to be that if the court accepts to pursue with the derivative action, it then becomes an action from the corporation against whomever is at fault, and if they win, the director that has been at fault will have to compensate the company and possibly pay costs. If they don't win, then the company is burdened with those costs, but not the individual who initiated the action.